I would say it is if the notion of appeal.
Whereas the same powers is being enjoyed by the High Court and the Federal Shariat Court under Article 202, 201 and 2 and Article 203J. What are those requirements which prompted the Parliament to constitute this Act?
I would not like to, because a lot has been said as to why Parliament did it. To me, the central issue is whether Parliament had the constitutional authority.
Not talking about that.
But the absence of the exercise of one constitutional power does not mean that an exercise of another constitutional power is unconstitutional. I mean, Parliament can tomorrow maybe exercise that also. वो उस वजह से तो नहीं हो सकता.
Same authority is being used by two other courts, but
Yes.
specifically it is done with the reference to the Supreme Court.
But exercising one kind of power is not barred by not exercising another kind of power. But the real issue is whether Parliament has this power and to what extent does it have
Just to
this
resolve this, Mr. Attorney General was repeatedly asked to bring the record of the legislation.
Maybe he
Perhaps
can
that
answer
has not
that.
been-
He is in a better position, sir. But I take your lordship's question.
There's one more question on the jurisdictional or jurisprudential plane. Basic principle is that an appellate forum or right of appeal is provided by the statute which confers the jurisdiction in the first place. Right? Right or wrong?
Not an absolute rule.
Okay. A statute doesn't provide an appeal. Another statute can provide, on the same footing, it can provide an appeal. Or an amendment in the statute can provide an appeal. Here, the jurisdiction creating statute or instrument is the Constitution. If a right of appeal is to be provided, it has to be provided by the Constitution, not by sub-constitutional legislation. Because the effect of sub-constitutional legislation would be that you would be conferring the powers on a sub-constitutional instrument to provide such appeal. Is that doable jurisprudentially?
My lord, the position which I've stated before your lordship, and then I'll move on, I'll just state, because I'm very conscious of the fact that your lordships have taken a different position in the Ghulam Muhyiddin case. I will deal with that judgment when I come to that. But my position is number one. If this appeal under this statute is unconstitutional, then the appeal under the law reforms ordinance is unconstitutional.
मैं सिर्फ प्रिंसिपल आपसे
इसीलिए मैं प्रिंसिपल की
वो
बात
if तो ठीक है, I mean उसका जवाब तो ये है, one, those matters are not before us. Two wrongs would not make.
and the appeal under the contempt of court ordinance has been upheld as constitutional by this court.
Yes.
That
Under
is also an
different
intra-court appeal by a
circumstances,
statute.
Under different circumstances and for different reasons.
जी.
मैं आपसे ये पूछ रहा हूँ कि ये jurisprudential जो principle है कि आप किसी और statute से which is not on the same plane as the original statute which conferred jurisdiction, आप right of appeal provide कर सकते हैं considering that it is a substantive right. So by sub-constitutional legislation, can you exercise the same powers as are envisaged in the Constitution, i.e. creating a right of appeal,
My lord, your lordship,
ignoring the fact that the instrument that creates the jurisdiction does not provide an appeal?
my lord, I think the instrument which creates the judicial forum in the first place is irrelevant. The issue is whether that particular provision has a bar to creating such an appeal through an ordinary statute, number one. Is there any bar in Article 185 that such intra-court appeals cannot be created? What I'm trying to understand, where does this bar come from?
From the language itself, subject to the
language?
constitution and the law. You see, you're relying on this language to say this is enabling and this gives competence. But there are other language where the constitution gives enabling powers to parliament and gives it competence. It's totally different language. So you are not creating any difference in that language. You are not saying that where the constitution is saying it may by law or it may by or under any law, which is a direct power that it is giving to the parliament, you are not making any distinction there. You are just saying read competence into the word law. The word law has been used over 400 times in the constitution. Do we read competence into every word law is used, or do we now start distinguishing yahan law ka kuch matlab hai, yahan law ka kuch aur matlab hai? That's why for interpretation you follow principles. So which principle are you following? And on what principle will we be able to say in the next case and the next case that this is the principle that we followed?
I think these are two separate questions. Your ladyship is still on the question of competence. The judge has asked a question regarding procedure. These are two separate questions which should not be
confused.
confused.
It's not separate, it's the same, and it goes back to
question
Justice
of competence.
Shahid's question as to the manner in which any change in the jurisdiction given by the constitution
Where is the bar in the constitution which says that a
175
constitutional forum created by the constitution bars a statutory remedy? Where is the bar?
Acha, can you cite any example where the jurisdiction creating statute does not provide an appeal, and by way of subordinate legislation an appeal has been provided?
Float.
Or to extend the example further, through another statute which is not on the same plane, an appeal has been created.
My lord, your lordship doesn't have to go to statute and rules. Your lordship just has to look at constitutional forums
That
and
is
intra-court
precisely the
appeals.
point.
Intra-court appeals.
That is precisely the point.
I think Article 270 is answer to the question, where the constitution maker has upheld the jurisdiction of the parliament to enact by providing to the Supreme Court. The case may 270